welcome to the third of the 3 events that we're holding for the Institute of Arbitrators in the Thames Valley on contract administration. Whilst we're called members of the Institute of Arbitrators, the majority of our members are not arbitrators, but we're all involved with dispute resolution in some form or other. So there'll be adjudicators, there'll be expert witnesses, there'll be mediators, and a few of us are also practicing arbitrators. And our branch of the Institute of Arbitrators is the Thames Valley branch, which is roughly Berks, Bucks and Oxon, and it pinches 1 or 2 bits of other counties. And we've got about 240 members, and we regularly hold meetings all over the 3 counties. In particular, we've had a series of 3 here, and we're also having a series coming up in the autumn in Reading and Maidenhead. So just to tell you about some events that will be coming up over the next few weeks and months, this is one that I can now confirm is available and you can book it. So we have the chair or the chairwoman of the JCT who is going to be coming to speak to us in about a month's time about, or at the end of July, on Wednesday the 31st of July, about the 2024 stable of JCT contracts. So we're very lucky to have Karen Kirkham, who is their chair, coming to speak to us. The next event after that will be in September, when Will Minting will be talking about neighbourly disputes, and he'll be spilling the beans on some high-profile disputes between neighbours. So that's something a little bit different. Both of those events are going to be at Maidenhead. In October, we have a 1-day expert witness seminar. Now, this is a paid seminar. It's 9 till 5, and we will be taking you through all of the essentials for undertaking expert witness work. So I would recommend that one very strongly to you. Later in October, we have Jenny Guthrie, who is a director and in fact a founder of Pythagoras Recovery, and they'll be looking at the ability to adjudicate insolvent claims or claims where one of the companies is in insolvency. I've heard her give this talk before. It's absolutely brilliant. So I would recommend it. And the next event that's then already fixed is we have a panel of practicing mediators who'll be speaking only online in November. So go and look at our website and you'll be able to book up most of these. 1 or 2 of them not yet up, but the majority are already there and already available to be booked. So what I'm going to do then now is quickly close this one, and I'm going to go to the event for this evening. And okay, so Eddie, are you able to get that up as well? Thank you. So this is the third of the series of 3 that we decided to set up on contract administration. So we've done a week looking at practical completion. We've done a week looking at extensions of time. And now I'm going to be looking at payment procedures. And we've got a range of delegates that are going to be registered for this course, both in the room and online. We know that we've got architects, lots of building surveyors, project managers, quantity surveyors, contractors. Now, in our branch of the arbitrators, we have a masterclass that we run, which is a half day. It's 4 hours on this topic, on all aspects of payments, invoicing, subcontracts, various things from other angles. But because this is a series for contract administrators, I'm going to concentrate on aspects from a CA's point of view. So I'm going to be concentrating on payment notices and, in fact, certificates, and then Payless Notices. And I'm going to start by setting the scene. I'm then going to go through and look at what the statutory requirements are for payments. In other words, what statute says. Then I'm going to revert to the JCT, because the vast majority of the audience that we have are going to be working off JCT. So I'll have a look through the payment procedures under the JCT. And then at the end of the talk, I'll give you some key pointers of things that you must do in a payment notice and in a Payless notice. And I'm going to be asking the people in the room some questions, but I'm going to be saying to the people online, also have a go at answering these questions. So it will be a similar sort of reflection. And let's get straight onto those. It's going to make you do some work. So in the room, how many people here can tell me that they know about the Local Democracy, Economic Development and Construction Act of 2009. So let's have a show of hands. How many people know this act? Well, as in, who's read it? How many people have read it? I've got one hand up. Okay, I've got one hand up out of about 25. All right. So the one person with a hand up, you can answer this. All of it? Have you read? Oh, okay. Yes, I'm only talking about the amendments. Okay, so we've got a know all in the room. That's great. Thank you. And by what name is it normally known, sir? Well, yes, I don't call it that, but yes, all right. You can call it. It's got some very, very silly initials. Okay, let's widen this out. How about this one? And again, I'm going to ask hands up in the room. Who knows what the Housing Grants, Construction and Regeneration Act of 1996 is all to do with? Hands up. Oh, we got one or two. Yeah, we got a few more there. Right, okay, and who's read it? Yes, same, we got the same one, no, all of it. Yes. You did a dissertation on it. Excellent. You can come and give the talk. And by what name is it normally known? Yeah, Housing Grants or Construction Act, also known in the early days as the Hugh Grant Act as well, but we won't go back there. So I'm going to ask the one person who actually knows these two, in a nutshell, what's the difference between them? And the main amendments are to do with what? For everybody else, the answer is in the bottom line there in red. It's all about the payment provisions, which is very appropriate for what we're doing tonight. So we're going to be looking at the payment provisions. And these basically are the Construction Act of 1996. That's the one you see on the screen. And then it was amended. It was amended in 2009, applicable from 2011. And effectively, the second one just amends the first one. So what we've got is that the two of them combined are now the updated Construction Act. And if I'm just going to refer to it as the Act, but it's the Construction Act. So I do a lot of professional indemnity work. What do you imagine when there are claims made against quantity surveyors? What are most of those claims going to be for? Any suggestions in the room? Non-compliant payment notices? Yep, I wouldn't disagree. It's all about overvaluation and problems with payments. Now, we only have a handful of QSs, but we've got building surveyors and architects. There will be lots of other things that architects and contract administrators can be sued for. So failing to spot defects, not issuing notices when they should, etc., etc. But at the end of the day, you also get sued an awful lot for getting your payment notices wrong, because as I say on the slide, it's all about money. So ultimately, it all comes back to making sure you get these things right. And again, show of hands, I've got a lot of CAs in the room. How many of you have ever let a contract without the use of a standard form of contract? So an exchange of letters or just accepting an offer that was, being given by a contractor? Yeah, a few hands are going up there. Exactly, at the bottom end, it goes on all the time, one of the delegates is saying. So in those circumstances, will there be some terms and conditions? Well, there might be the small print that the contractor's put into his offer, in which case, did you read those terms and conditions? Did you actually go through them? Very often you find that people don't read, they just take it on trust, and then it's all going to go downhill from there because people didn't realize what they were signing up to. And the best contracts are the ones that you sign and you put in the top drawer and you never read, because you don't have to invoke any of the clauses. When it all goes wrong, that's when we get the contracts out of the top drawer and then we read what we've actually let ourselves in for. Okay, so in the room, again, a show of hands, how many people use the JCT forms of contract? Virtually every hand is going up there. Okay, so which ones are we going to use? Well, who's using the minor works? Yep, quite a few. Keep your hands up. What about the intermediate? Yep. And then we got standard building contract. Now, as this is a series of talks on contract administration, I'm only going to be looking or talking about these because these are the certifying contracts. These are the ones where you're acting as contract administrator. So whilst I can lecture about the design and build and about the some of the other contracts, today is all about what it says in these, because this is the one where you'll be acting as a CA. And be warned if you go making amendments to them, because I sometimes see amendments to contracts where the amendments are longer than the contracts themselves. And despite that, people get them very badly wrong because they don't get them to be consistent. So, all right, now I'm hoping that there won't be any hands up. Anybody still using the 2011 version? Good. We do still see them occasionally. So let's just take a poll. I've got a standard JCT. This is, put your mind back to 2011 if you can, and see if anybody can remember. You've got an intermediate form of contract. It's going on for 12 months. It's unamended. So how many interim payment certificates or payment certificates would you expect to be issuing? Other than the chap who wrote the dissertation on the Act, anybody else tell me, let's have an architect or a building surveyor. How many payment certificates would you issue? Eh? How did you get to 14? Not quite right, but you're in the right ballpark. Any suggestions in the alternative? Right. Well, straight away, yep, there'll be 12 for interims. In fact, the answer is something like that. It'll be 12 for the interims, 1 at practical completion, because you used to have to issue a certificate within 14 days of practical completion. Then you should be issuing a certificate every 2 months under the old 11. It was every 2 months. So it was a 6 months default period for the rectification period. And then you'd have the final certificate at the end. So that was the old system. If you were doing it on a JCT nowadays, a JCT intermediate nowadays, what would it be nowadays? That same guy, because he can give me the answer. 14, same answer. No, it isn't, because now they've dropped the 1 at practical completion. So you're going to have 12 during the job, but you have to do them monthly, every single month from practical completion up to the final certificate. And that's something that an awful lot of practitioners get wrong. You've got to be issuing them, as we'll see, every single month. And if I did the minor works, I'm just going to go through these. So on the minor works, the weird thing was the minor works used to be every 28 days. So you'd have had 13 certificates, and then you'd have had 1 at practical completion, and probably on the minor works, it was a 3-month rectification period. So you'd have had 1 in the intervening period, and then 1 at final certificate. And nowadays, it would be 12 plus 3. So let's now get onto the Act and talk about the Act, because the 2 things together with all those initials, which I'm not even going to try and turn into a Scrabble answer, they just get combined to be called the Construction Act. And what did the Construction Act bring in? Well, in simple terms, it brought in 2 major things. Firstly, it brought in a mandatory right to adjudication. It also brought in statutory rights to be paid. So it had 2 really important things in it: adjudication and payment. And if you fail to comply with the minimum requirements of the Act, then you get implied terms which are implied from statute. And that's something which you can see on the screen called the scheme. So the scheme would come in and it would trump and fill any gaps that you've got in your contracts. So schematically, this is how the 1996 Act was laid out. And we're not interested in all the stuff at the top. All we're interested in is down at the bottom. There were 4 parts to the bit we're interested in. We're interested in part 2, construction contracts. And there are 4 parts to it. And what you've got is like a thick sandwich. You've got 2 bits of meat in the middle of the sandwich, which are 108 adjudication and 109 to 113, which is payments. The other bits at the beginning and the bits at the back, they're just housekeeping. And I'm going to quickly run through them and point out the bits that are important. So if we do the first bit, 104 and 105 tell you which contracts are going to be caught by the Construction Act. And whilst there were some exceptions, it's pretty much all straightforward building work. But there is one big area of exception, and that's 106. It doesn't apply to domestic properties if you're doing work on Mr. and Mrs. Jones's house. If, however, it's a second home, or if it's you're doing work on your mum's house, but you're entering into the contract, then it isn't a contract on your own residential property, and you would still be caught by the Act. So it's only work on your own home which is going to be exempt. But even in those circumstances, as we heard, the vast majority of you will be letting contracts using a standard form of contract. The standard forms of contract are all Construction Act compliant. So even though you don't need to go and look at the Act, you will still get the provisions via the contract. And I'll point those out to you later on. Forget 107, that's now gone. 108 on its own is about adjudication, and we could lecture all day about adjudication, but that's for another day. And then this is what we're going to be concentrating on tonight, and only 3 of these sections that I'm going to look at. So I'm going to be looking at 109 very briefly, and I'm going to be concentrating on 110, 111, and those are the ones that are the subject matter for tonight. 112 just says, and we won't go into any depth, it just says if a contractor is not paid on time or is paid light, then for the first time ever, a contractor would have a payee, the person receiving the money, would have the right to suspend their operation. Now, we've all had situations of contractors walking off site and saying, I've not been paid, I'm off, but then that's a breach of contract. And there's no common law right to do that. 2 wrongs don't make a right. But this Act gave, for the first time ever, a right for a contractor to suspend his performance of his contract if certain circumstances existed. But that's 112. And 130, sorry? Oh, you have to do it under, yeah, there's a strict way to do it, but we're not going to cover that tonight because I'm talking about payments. So we're going to make sure you get the payments right so that no opportunity for somebody to suspend ever arises. And the last one was, it was a complete ban was introduced under section 113 on pay when paid clauses. Again, not a subject that I'm going to cover tonight. And then the supplementary provisions at the end, well, that introduced 114 allowed you to bring the scheme in. 115 tells you about service of notices and when they're deemed to have arrived. 116 is worth mentioning to you. All the way through what I'm going to cover for the next, 3/4 of an hour or so, is going to be about times. And every day of the week counts apart from bank holidays. So if it says days, it includes Saturdays and Sundays. The only things that don't count are bank holidays. And one other point I'm going to make now, if you've got a requirement to issue a notice, which we'll come on to, and you've got to do it by midnight tonight, if you issue it at 11:59, it's okay. It's going to be an okay notice as long as it does what it should do. If you issued it at 1 minute past midnight, it's as if it never existed. So these times are absolutely strict. You must stick to the times, and there's case law on this. So, section 109. Now, I've given you on the screen, and you'll all get the slides. They'll be sent out to you. But I've given you a simplified version of 109, 110, and then 111. This is very similar to 109 because there's not much in 109, but the other sections are much longer, and I've had to make them simpler. Section 109 says the following. A party to a construction contract is entitled to payments by installments, stage payments, or other periodic payments for any work, unless the job's going to be less than 45 days. So on any job that's going to be 6 weeks long or a month and a half, to be more precise, you must have a mechanism in your contract to introduce interim payments. Now, in common law, you don't get that. I know we all assume there'll be monthly payments, but actually, if it's not in your contract, there is no common law right for interim payments. So this, for the first time, introduces it that there must automatically be on any job that's going to be more than a month and a half long, you've got to have some other mechanism for doing interim payments. I'm going to concentrate on monthly. So we could get stages, we could get threshold, stage payments and all the rest of it, but I'm going to concentrate on monthly. And the parties are free to agree how they will go about the payments. So it's very much allowing you to do what you wish to do. And now we come on to the meat in the middle of the sandwiches. And this is where you're going to need a bottle of scotch and a wet towel, because it's going to get complicated. And I'm going to try and simplify it as much as I possibly can, but it will still be a bit complicated. And I'm going to give you the ladybird version, the easy version. So let's look at the words. Every construction contract shall provide an adequate mechanism. So there's got to be a method of determining what payments become due and when. And it must provide for a final date for payment in relation to any sum which may become due. Now, these two words, due and final, are really, really important. And please don't be misled. Please don't think that the word final is indicating that this is the final payment under a contract, i.e. the last one. No, this is a mechanism that goes on every single cycle. So every single month, you must have an identified due date and an identified final date for payment. I like to think of the final date for payment as being the date when the payment becomes overdue. All right, so there's a time period within which the payee, the employer, can make the payment, and after the final date for payment, they're offside, they are now overdue. And then it says, the parties are free to agree how long the period is to be between the date on which the sum becomes due and the final date for payment. So it's completely in the gift of the person drafting the contract to decide how long that period will be. Now, I've seen some pretty nasty things because I specialize in dispute resolution. The worst I have seen is 156 days. That was even worse than the Carillion. They were about 120 days. So if they were 4 months, but no, I've seen 156, which was 5 months. It also had 15% retention, which nobody noticed, but we won't go there. And the mechanism, just to point out, and there's been some case law relatively recently, you cannot have circumstances making a final date for payment dependent on another event happening. So whilst you could say a due date hasn't arisen because, for example, somebody didn't send in an invoice, or somebody didn't send in a VAT invoice or something like that, you can do it for the circumstances as to when a sum becomes due. But case law in the last 18 months says you cannot interfere with the mechanism for the final date for payment. There's a case involving Lidl and CCC, their refrigeration subcontractor. They tried to make it that the final date for payment was only when you sent in the invoice. And the judges said, look at the words, it is the period. It's the period between. It has to be a number of set days. So you can't make that dependent. Anyway, so then we're now getting into the amendments. So what the amendments did, they introduced section 110A and section 110B. And I'm going to simplify it because there are lots of little wrinkles in there. But if you think of 110A as being the payer, the employer issuing payment notices, and if you think of 110B being the contractor having the right to issue a payment notice, as I'll explain, it's the simplest way of thinking about it. Because the problem with the old Act under 1996 was that the requirement we've just seen, or we're about to see, is that there was always a requirement for somebody to issue a payment notice, but there was never any sanction if that payment notice didn't exist and didn't come into existence. So what the Act amendments did was to make teeth and to have a situation whereby the contractor, if no payment notice was issued, the contractor was then in a position to issue a default notice, a notice to take its place, as we will see. So let's start with the traditional, the situation of the payer's notice. So 110A, the construction contract shall require the payer or a specified person, so it can be you, the contract administrator on their behalf, to give a notice to the payee, that's the person, let's imagine it's an employer and a contractor. So the employer or the architect on their behalf must give to the contractor not later than 5 days after the payment due date a notice which is going to set out the sum considered to be due at the due date and the basis on which that sum is calculated. So we've always had this since 1996, a responsibility on the employer or their architect or building surveyor to issue a payment notice. And they've got to do it within 5 days. Now, we saw that other dates are variable under the contract. This one is not. This one is set by statute. You cannot change this. It's got to be done in 5 days from the due date. And if you're working on a job and you did a valuation last month, you go to site this month and you suddenly see a load of defective work. You notice the defective work, you therefore decide that actually the value this month is less than last month. You can't say to the contractor, I'm not going to issue a certificate this month because you've done no extra work. You're not entitled to any extra money. You've still got to issue a payment notice, even if it's going to be in the sum 0. You've got to issue it. Otherwise, you're putting yourself at risk of there being a default notice. So that's the requirement. You've got to do it, and you've got to issue it within 5 days of the due date. And then we get on to the amendment that has given teeth to this and has given opportunities for the contractor. So section 110B, and I've labeled it a payee's notice. That's not what it says in the wording. I've simplified it as payer's notice for 110A and payee's notice for 110B. And let's see what it says. It says this section applies if there isn't a payer's notice, a 110A notice. And then it says, subject to what it says below, the payee may give the payer a notice at any time after the 5 days. So that 5 days is available for the architect and the employer to issue their payment notice. But if they don't, then the contractor can issue his own notice. And let's imagine a situation. The interim certificate, as we'll see it's called, or under a JCT, or a payment notice, is going to be issued on behalf of the employer. It should have been issued by Friday. Friday was the 5th day, and it wasn't issued. So the contractor thinks, oh, it's in the post. Okay, I'll get it Monday. And then doesn't arrive, it's not there. So Tuesday, he phones the architect, and the architect said, oh, no, I didn't think there was anything. I didn't know I had to do it. I haven't issued it this month. Right. So what we have there is that that payment certificate is now null and void. It's lost its opportunity. It doesn't exist. The emphasis and the opportunity is now passed to the contractor. So the contractor, in default of that notice, is now able to issue his own notice. And he could have done it on day 6. He could have done it at 1 minute past midnight, but he hasn't. He's waited another 4 days before he issues a default notice. So what happens to the timetable is there would have been so many days between the due date and the final date. Those 4 days that the contractor delayed issuing his payment notice in default, they get dotted on to the final date. So if the final date was going to have been in 10 days' time, it will become in 14 days' time. So whatever the delay is by the contractor in issuing his default notice, that gets tacked on to the timetable later on. I'll show you in a table in about a quarter of an hour's time. But very important, then there's also this bottom provision in 4. Now, if the contract permits or requires the payee, the contractor, to make an application for payment, then he doesn't need to do a default payment, because at 1 minute past midnight, it automatically became the default notice. And the JCT has got this in there. So if you haven't issued your payment notice, interim certificate, within the 5 days, you've lost your first opportunity to do what you should have done on the pitch, which was to decide what the payment is. And whatever you write now is useless. It's out of time. The contractor's application has automatically, even though it might have been spurious, and as long as it's not fraudulent, if he's put in for 100,000 more than you think is really what is due, I'm sorry, but that's now the payment notice. It's something that we'll see on the next slide has become the notified sum. So that is now the payment notice. And it automatically happens where the contract permits or requires an application for payment. And let's face it, the vast majority of us anticipate the contractor is going to make an application for payment. So, architects, you're okay. You haven't cocked up completely. You just forgot to issue a payment notice, but you've got a second bite of the cherry, and you've got an opportunity within a narrow window to issue a pay less notice. Now, it's actually not called in the Act a pay less notice. It's called a notice of the intention to pay less than the sum that's now become notified. And let's look at that. So the word notified sum, in fact, it's headed notified sum in the Act, but I've changed it to pay less notice so that you know what we're talking about. Let's see what it says. It says, subject to what's going to be said below, the payer must pay this new word, notified sum, by the final date for payment. So you've got to pay this employer, and the notified sum is then explained. And it's either explained as being what was in the payer's notice. So what the architect, if he did issue it, if he issued a certificate, then, and the client didn't like your certificate, the client's got the opportunity to still issue a pay less notice. Or if you suddenly notice, architect, you issued a payment notice for 100,000, and then you suddenly, 2 days later, realize that all the plaster work is live, and you thought it was good and it sounds hollow, then you still have the right to issue a pay less notice against your own certificate. So as the employer, you have 2 bites of the cherry. So it can be set against either your own payment notice, if there is one, or it can be paid, go against 110B, which would be the payee's default notice. So it can either be a default notice or it could have been that application for payment. I'm going to take questions at the end, Paul, because we're late starting and we won't get through it. So this can be given by the employer or a specified person on their behalf. And what you have to do is you must set out the sum the payer considers is going to be due. One little wrinkle, you don't set out the sum that was due on the due date. You now set out the sum that's due on the notice date, which could well be 10 days later. It's a bit of a wrinkle. I've never got my head around why that is, but you've got to be seen to value to the date of the payless notice. All right. If you were to write a payless notice and you said valued to the due date, it would be invalid. And again, you would have therefore shot yourself in the foot, and you would have lost. You didn't do a payment notice, and you'd have then mucked up your pay less notice. So you've got to value to the pay less date on the pay less notice. And you have to set out the calculation showing how it's been calculated. So in each of these, you've got to say what's going to be paid and how it was calculated. And the same thing applies with payment notices and pay less notices. And the notice of the intention to pay less mustn't be given later than a prescribed date. So we'll see what those dates will be, but it means that you can't be too late. There's going to be a certain number of days before the final date for payment that you have to issue this thing. But equally, you can't issue it too early. You can't issue a pay less notice, not until there's a notified sum. So the notified sum doesn't exist until there's a payment notice or a default notice. So it's a very, very narrow window within which you can issue a pay less notice. And prescribed period, well, that can be played around with, but it's got to be a prescribed period so many days before the final date for payment. Now, what contractors always do with subcontractors is they move it to 1 day. So they give themselves the widest possible window for them to be able to issue a Payless notice. Most employers don't do that, but the canny ones and the developers who are used to get to building, they will also extend that period so that the Payless notice is only, say, 1 day before the final date for payment. And we have various notices under the Act. Now, there are chronologically 4 notices that could exist. The first one is the application for payment. And you might say to me, Mark, I don't think that's actually a notice. But if you look at the words, which I've put down at the bottom, it says, if the contract permits or requires the payee to make an application for payment and the payee gives such notification, so there is a requirement for it to be notified, so it is a notice, even though it doesn't call it it calls it an application for payment. So it is a sort of notice. And it's very important when we come on to see what the case law says about what must be in a notice and how a notice shall be issued. Then we have the payment notice, which we've just seen as the payer's notice. We've got the default payee's notice, which is section 110, and we've got the Payless notice, which is section 111. So there are basically 4 types of notice that you're going to have on a construction contract. And I'm going to jump ahead a little bit here. There is, in the case law that we've had over the last 10 years, or slightly more, but it really hit from 2014 onwards, the judges have implied that maybe you don't have to be quite so good at the way that you explain a Payless notice. I'm going to advise you from the outset, treat all 4 of these in the same way. I think you should really be going to town to give the detail in all of these notices if you don't want to fall foul and have somebody say that that's an invalid notice. So I would say treat them all similarly. So I'm now going to start to look at the JCT, and this slide, we'll come back to it in a minute, but this slide is just to show you that the JCT, when they were issuing their forms of contract, they decided not to adopt the terms from the Act, but they've called them different things. So what you've got is the words in black here on the right-hand side, they're the words that will come from the Act. Just to fit it on the screen, I haven't said notice of the intention to pay less. I've called it a Payless notice because I hadn't got enough space on the slide. But all the words in black are taken from the Act, and I've just shown you where they come from. But the JCT decided in its 2016 version that it would introduce a new date and a new term, and it's completely changed the way that you should do things. And everything that's going to be important is the interim valuation date. And I think the thinking was trying to get an architect's certificate issued within 5 days of the due date didn't give you long enough in practical terms to issue it. So what they did was they said, what we're going to do is we're going to introduce 7 days earlier an interim valuation date. So effectively, everybody's going to work and aim for the interim valuation date as being the date that you value to. But we've now given ourselves 12 days within which to issue our interim certificates. So let's go and look and see what the JCT says about that and how they word it. And because I knew that we'd have people dealing in the small end and the big end, I'm going to do the middle one. So I'm going to base what I'm going to talk about for the next 10 minutes on the intermediate form of contract. But I can tell you that the wording in the minor works and the main standard form of building contract, although the bigger one obviously has a lot more words, it's nevertheless the same mechanism. So let's look at when you're going to have the valuations. So 4.8 tells you about that. The first interim valuation date, unless you change it, which you've got the right to change, is 1 month after possession, and thereafter the same date in each month. So it's dead easy. It's going to be monthly, calculated from the date when you took possession. So straight away, we're going to be able to identify what the interim valuation date is. And from there, we've straight away, I'm going to go back one, but so straight away, we now know when those interim valuation dates are. So you now have a cycle for knowing when the due date is every month and when the final date for payment is every month, because the JCT has given you a mechanism. So let's see what they then say about due dates and certificates. So straight away, they don't call them payment notices. What you issue is a certificate. You either issue an interim certificate or one final certificate. So they don't call them payment notices from the payer. They're payment certificates from the architect. So the monthly due date shall be, as I've shown you on the chart, 7 days after the interim valuation date. So they've given themselves 7 days until the due date and another 5 for you to issue your certificate. And that's the next clause. 482, the CA shall not later than 5 days after each due date issue an interim certificate. So I put it in green to emphasize that they chose some different words. This is a JCT word. And you've got to state the sum that you consider due at the due date. Interesting. That's the same identical wording as the Act, but it then says calculated in accordance with clause 4.9. So we'll come on to 4.9 on the next slide. And you've got to say how the valuation has been calculated or how the certificate has been calculated. So you've got to tell us when we're going to get paid. That's from the final date for payment, and how much we're going to get paid and how it was calculated. But let's see what 4.9 says, because that rather implied that you were valuing to the due date. It says the sum due at the due date. But then you look at 4.9 and it says the amount of each interim payment to be certified under that clause we've just seen shall be the total of calculations. And don't worry about this. It's just, it'll be materials, it'll be labor, it'll be, you know, all of the work you've done, less what you did last month. But it says calculated as at the interim valuation date. So they've made it perfectly clear that whilst you will say the sum that is due at the due date, you're not calculating to the due date, you're calculating to the interim valuation date, and it becomes due 12 days later. Okay? Not 12, 7 days later. It becomes due 7 days later, and then you've got 5 days further to issue a certificate. Now, I've put down at the bottom, so it'll be on the slides. Compare that with the words in the Act. So the Act said, considered to be due at the due date, and the basis on which that sum is calculated. So save for the fact that they've made it perfectly clear that you're valuing to the interim valuation date, I think it is probably Construction Act compliant. Right? But there was a dilemma there. Nobody's tested this. Then we come on to some more words about a payment application. So this is what the contractor is going to do. So let's see what it says in the JCT about what the contractor can do, either by his payment application or by his default notice. So in relation to any interim payment, the contractor shall, no later than the interim valuation date, make an application to the QS, a payment application, stating the sum that the contractor considers to be due to him at the relevant due date. Now that's interesting. Didn't tell him to value it to the interim valuation date. In his application, it says considers to be due to him at the relevant due date. There is no reference in here to clause 4.9 at all. So I think that somebody might take this at some point, because that part of the JCT is inconsistent with the next bit, which I'm going to show you, which is this is an application for payment, but let's just say there hadn't been an application for payment. Let's just say the contractor hadn't applied, the architect hadn't issued a payment notice because he didn't think there was a need because the contractor didn't apply. You've still had a duty. If the contractor doesn't apply, you don't go to sleep. You've got your job to do as CA to issue it monthly, every single month, regardless of whether the contractor has applied. You've still got to do it. Different under the JCT design and build, that's a contractor-led one. But under the certifying contracts, you have a duty to issue them regardless of whether they've applied. So it doesn't, so if the contractor was going to put in a default payment, that's the next clause. If a payment certificate isn't issued, then the contractor, where the contractor has made a payment application, that application effectively becomes the payment notice. So exactly the same as the Act. This bit under 4.11.2.1 says that the application, if there is one, automatically becomes the default, it becomes the payment notice. They call it the payment notice. So they didn't call what you issued a payment notice. They're using the expression payment notice only for the contractor's application, right? But when we come to 2, this is the default one. Where the contractor hasn't made a payment application, he may at any time after the date when you should have done your payment notice, so from the 6th day onwards, he can send to the QS a notice stating the sum that he considers would have become due to him under 4.9. Now that's interesting. So his payment application didn't refer to 4.9. 4.9 is the one that says value to the interim valuation date. So there's an inconsistency there in the JCT. I'm not expecting you lot to get worried about this because most of you don't work for contractors. And it won't affect you if you're issuing certificates or payless notices. This is the nerdish stuff for people like me, adjudicators and people who do dispute work. This is what I'd be doing as between contractors and subcontractors. So notice, as I've put at the bottom of that slide, there is an inconsistency in the JCT between what it says about an application for payment and what it says about a default notice. So final date for payment under a JCT, the final date for payment will be 14 days after the due date. Now, it often gets changed and you can change it, but the JCT unamended is 14 days. And then subject to any payless notice, the paying party shall pay the sum stated as due in the payment certificate by the final date for payment, or if there's no payment certificate, then they must pay what's in the contractor's default payment notice. So by the final date for payment, you've got to pay what the sum is on one of those two things, whichever exists. And I've just said, so effectively, this is the JCT version of paying the notified sum that we saw 15, 20 minutes ago under the Act. Just as use different terms. And then, what does the JCT say about payless notices? Well, it does call them payless notices. It uses the term capital P, capital L, payless notices. So where the employer intends to pay less than the sum stated in one of those two other things, the payment certificate or the payment notice, then not later than 5 days before the final date for payment, then somebody can issue on their behalf a pay less notice. And it can be given, as it says at the bottom, shall specify the sum he considers to be due to the other party at the date of the notice, as we saw, that's what the Act required, right? And the basis on which the sum is calculated. So you can't just say, I'm going to pay you less. You've got to say, I'm going to pay you less, and this is why. So there is a schematic showing you all of these. So down at the bottom end, it can be any time you like, virtually before the interim valuation date, the payment, the contractor can apply for an application for payment. Then we have the 7 days before the due date arrives. Then we have the statutory 5 days, which cannot be moved. That cannot be moved. The 7 only comes from JCT. That's the JCT version. So you've got to be issuing an interim certificate within 12 days of the interim valuation date. Let's jump to the other end. And the final date for payment we saw was 14 days after the due date. So there was a 14-day period. The first 5 you could issue your certificate in. You had up to 5 days. And JCT has just told you, you can issue a payless notice no less than 5 days before the end. So I put those in grey. So that means under an unamended JCT, you've only got 4 days in which to issue a payless notice. So this is why I said often people will change that and they'll move the final date for the payless notice up to, say, day 20 to give themselves a wider window for issuing the pay less notice. But this is the standard basis of an unamended JCT. So let's see what case law has got to say about issuing of notices. So I've shown you what the Act says. I've shown you what the JCT says. Now I'm quickly going to run through a few cases. And notices, I'm going to go back before the Act, and I'm going to go right back into the 19th century and then back into early 20th century. Oh no, 1895 and 1942. And if people did not issue notices when they should have issued notices, this comes into leases, actually. It's to do with landlord and tenant. But if you were one day out with a lease notice, it fell away. And in the second case, they actually said the courts shouldn't aid people who make slips. So the attitude was that issuing of notices had to be absolutely strict. But this got overturned by the House of Lords in 1997 in the Manai case. And the Manai case looked at it. It was a majority decision. I think it was 5-2 in the House of Lords. And they introduced something which is known as the reasonable recipient case, which effectively said, look, if there's some tiny little technical breach where somebody, it was perfectly clear to anybody who was reading these papers that they meant it to be on the 13th of the month because that was the day when there was an opportunity to issue a notice. And by mistake, they said Thursday the 14th or whatever. It was blindingly obvious what they meant. So the reasonable recipient would interpret it and they wouldn't hold them to task for a minor slip. And whilst the Manai is not quoted in the cases we've had over the last 20 odd years in adjudication, it is mentioned in 1 or 2 of them, but it has been upheld all the way through the cases that the reasonable recipient test will be applied. So a bit of common sense will be applied to what you're going to do in your notices. But if you don't get certain things right, your notices will be useless. One of which is that you must issue them on the right date. That's absolutely fundamental. So arising out of these amendments, what we got was smash and grabs. So we got exactly the situation that I explained. You had a situation of a contractor puts in an application for payment. It may be worth £300,000 or £400,000. Certainly the one in ISG and CVIG was worth hundreds of thousands of pounds, and the college, or their architects more to the point, didn't issue any payment notices, didn't issue any pay less notices, and so it became that it was a notified sum, or as people more pejoratively call it, a smash and grab. In other words, doesn't matter if it was right, wrong, or indifferent, you have to pay the sum that was on that default notice or that application by the contractor. And in legal terms, I'm sorry, you are stuffed, absolutely stuffed. So we had a series of cases all the way through from 2014 onwards. I've only given you a couple, but in Coulson is the main man on this, now Lord Justice Coulson in the Court of Appeal. And in Severfield, he said, look, the result of this is it's draconian. If you miss these things, the effect is absolutely draconian because the contractor's going to get a pushover try, a smash and grab. So therefore, what the courts have tended to do is to rein this in, and they've started to impose quite restrictive applications that they've applied to mainly the payments or the applications for payment. But there's nothing in the Act and there's nothing in common law that says that any of these things should be treated any differently. That's why I put all 4 of those notices up there and why I'm going to advise you to use the same level of granularity and of attention to all the notices that are issued, because otherwise you run the risk of it being taken to adjudication and somebody saying that your notice was invalid. But he mentioned it in particular about the applications for payment. So there's always a big argument. Was the application for payment valid? I've got an argument on at the moment for 2.6 million on a smash and grab. So that's going to be interesting when I get to read what they've all got to say about it. And this got expanded by Aikenhead in Hennier and Beck. I'm only going to pick out a handful of cases. I could have given you up to 20 cases on some of these, which repeat and they go all over each other. But Hennier and Beck was Aikenhead, and he said that in particular applications for payment must be free from ambiguity. And also he went back to earlier law and he lifted some law from other notices, not payment notices, but he lifted some law that said because of the potentially serious consequences that flow from it, it must be in substance, form, and intent an interim application. So this set of words of substance, form, and intent gets repeated on a lot of other cases later. And he also said that something else that gets repeated. In this case, he said that your notice, the statutory provision needs to establish an agenda for adjudication, and a Payless notice must provide an adequate agenda for an adjudication. Now, what does that mean? It means that you've got to be able, if you want to go to adjudication over a notice, to have enough information in the notice to be able to work out what we disagree with and what we want to fight over. So arguably, and I'm going to be a bit radical here, if you issue a payment notice, a payment certificate, and all it says is 600,000, less 500,000 last month, 100,000, I'm going to suggest to you that that's inadequate, because we don't know how you calculated your 600,000. I want to see your workings. Otherwise, I couldn't go to adjudication over it, because I don't know how you've differed from me. I don't know what we're arguing over. So 25 years ago, Tony Bingham and I did a series of lectures on the Construction Act. And what we said back then, even in 1998, we said the perfect solution is to take your architect certificate and staple your QS's valuation to it. And if the two are actually for the same figures, and I hope they would be, then you've got an ideal payment notice, because it does everything it should do on the tin. I'm going to recommend that you still do that. You ought to have done a payment certificate where you've did some calculations. Show your calculations, then I've got an agenda for an adjudication. If the contractor wanted to take this as being a true valuation, he wants to argue with you in adjudication over what you've done your calculation wrong, or he doesn't agree with what you've said, he can go to adjudication over it. If you haven't told him how you did your calculations, arguably he could argue that that wasn't a valid payment notice. So don't give them the opportunities. Joanne Smith in the TCC, in a case called Advanced and Eniska in 2022, she went through a whole bunch of earlier cases and she codified them, and she found 8 different things. I'm only going to give you 3, but she basically said Manai is right. It's the reasonable recipient test. So don't get too technical about it. Look at the document and see if it makes sense and if it's pretty obvious how it was put together. It must, though, comply, and this is a bit debatable, but I think I'm not going to argue. They wouldn't listen to me as compared with Aikenhead and the judges. So she said it's got to be clear in substance, in intent, and in form. And we spend ages in this workshop, the 4-hour workshop, trying to work out what would be the substance, the intent, and the form of a payment notice, a payment application, etc., etc. I'm not going to do that tonight, other than to say to you, make sure it's blindingly obvious that what you're issuing is a payment certificate or a Payless notice. Don't mix up the terms. Don't imply that it's a final account statement, or that it's either an interim certificate, or it's a Payless notice, or it's the final certificate. Don't call it anything else, because in substance and intent, you're confusing things. So make it clear what it is. And it must be adequate agenda for adjudication. And she referred back to Hennier-Beck and another case. So it must be laid out with enough granularity for somebody to argue over it. So I'm saying, show your workings. And I would say, there's an implication, and she mentions it in advance, that you might not have to be quite so involved in the way you prepare a Payless notice. I'd advise you not to take that view, but go into as much detail on your Payless notice. Work out what you don't like, and then make it perfectly clear that you show how the Payless notice was laid out. So I'm going to start to summarize and give you some bullet points to take away. Having shown you where the arguments come from, shown you what the contract says, shown you what the Act says, I'm now going to go into things I want you to remember and take away. And my apologies for running over, but we had a bit of IT issues at the beginning. So with regard to your interim certificates, you must issue them on time. every single month, right the way up to the final certificate. So if it runs on, and if you haven't issued the final certificate and you haven't got all the information, you've still got to be doing evaluation every single month. And even if it's 0, you've got to be issuing it under a JCT. Specify the amount of the payment and show how the calculation was done and show your workings. If it's a JCT, issue it, valuing it up to the interim valuation date. But if it's not a JCT, I would suggest that you value to the due date, and then you're in compliance with the Act. And make clear that it's perfectly clear on the face of the document what it is in substance, form, and intent. So don't go using weasel words or wallying about words. Make it clear what the document is going to be. And for your Payless notices, you've got this very narrow window within which to issue it. You can't issue it too early, you can't issue it too late. So you can't issue it until there's a notified sum, and you can't issue it later than the prescribed period. So make sure you issue it in the right date, in the right period. Value it to the date of the Payless notice, not to the due date. Make sure, again, that it's substance, intent, and form. And as a little throwaway, if you're going to issue liquidated damages, which remember it's the client who issues the notice of liquidated damages or the intention to deduct them, then I would be issuing a Payless notice to deduct liquidated damages, because it's going to be less than the sum that was stated, because you won't be stating the liquidated damages. You don't take those off in your certificate. You have to take them off as a separate thing. So you would be issuing a Payless notice for the deduction of liquidated damages. And don't ever combine the two. There's case law on this as well. You cannot have a combined, under the 96 Act, you could, but under the 2009 amendment, you cannot have a combined payment and Payless notice. It simply doesn't work. And then the final takeaway for the CAs here, often you will see in Article 4, there is provision for you to put a QS's name in there. And I often see the architect write his own name in there. And I would advise against that, because you will be held to the standard expected of a reasonably competent quantity surveyor in all of the things. There aren't many, but all the things a QS has got to do, most of them he only does when the architect asks him to do it. But you would then be held to the standard expected of a reasonably competent architect. So my advice is leave that blank, don't put your name in there, but there are a few things you then have to change in the contract. So where we saw, for example, where the contractor has to make an application to the QS, just line that through and put in contract administrator. So anyway, ladies and gentlemen, I'm 10 minutes over. I hope that that whistle stop was of interest and has said what we said we were going to do on the tin, and I'm take questions. So any questions in the room or any online? Oh, Eddie, yeah.
For JCT contracts, if an interim valuation date is missed or late, will a subsequent valuation backdated to the date be invalid, even if the contractor raises an invoice in 9 minutes? Can the contractor go back at any time to a missed or late valuation date and issue a payment notice, even if there are subsequent valuations issued in line with the contract?
Yes. Yes. Once you're out of time, you're out of time. And at any time after the 6th day, the contractor could go back. And we do this. I've advised contractors. We've gone through all the mechanism, and we've gone through and we've seen which of the ones the architect missed. And we take the latest one of those and we go in for that. And, you know, we could be 3, 4, 5 months later, depending on what the architect has done. And particularly, this is really going to happen in the rectification period, because it's likely to be happening. And this is where people go to sleep. They don't think during the rectification period. So you go in and you work out which is the one that's most advantageous. And that's what you apply for as a default notice. And you hope that they don't notice it. Yep. Oh, sorry. Eddie, I'm conscious that they may not be picking up what the question is. So the question was, could a contractor come in late on an earlier valuation, you know, even if he'd issued an invoice for the amount that was shown in a later payment notice, a payment notice that was issued late? Well, if it's issued late, but it was perfectly clear that it was for the cycle in September, and he issued it 10 days late, 20 days late, doesn't really matter. It's invalid. It's absolutely invalid. So a default notice could be brought at any time, be that 3 months later, you know, 2 years later.
On when a contractor serves a notice of payment, is there a specific criteria for the information the notice must contain, giving wording to the effect of an application, or will a figure with basic numbers, stroke calculations be sufficient?
Right, well, there's a question here about what needs to go into an interim application. So I haven't concentrated on that tonight for the reasons that I said. I was looking at CA's role. But yes, we would spend a lot of time in the workshops that we do looking at what would make an application for payment. And as we've seen, the judges are much more prescriptive, and they would expect, because of the draconian consequence, if the architect doesn't issue the payment or a Payless notice, then they are going to be looking for that to be in great detail for the application for payment. So again, I would say to a contractor, make sure that it's got the, it calls itself an application for payment. Make sure that it shows the due date. Make sure that it shows the final date for payment. Make sure that it's perfectly clear which cycle it's for. So and then show how it's been calculated. Show, in other words, it's an application for payment setting out the sum that the contractor believes will be due to him on the due date or under a JCT at the interim valuation date. And that would then almost certainly be an adequate payment application, which, as we've seen, can become the default notice on day 6. So, Paul.
Yes, when you mentioned 2 bites of the cherry, and I got a bit very confused.
2 bites of the cherry. Right, question is 2 bites of the cherry.
I think you talked about the CA making an interim notice of payment, and then you might just, so you, on the basis of what you knew at the time, you've done your assessment, yeah, that passes all right, everything's paperwork's all right, and then you discover what has to be paid. Actually, it's not okay because something, it starts going wrong. It wasn't discoverable. I think that's what I think. Can you get another chance to?
Right. So the question is, when I mentioned the expression 2 bites of the cherry, right. So just to make that clear, the CA, the employer or a specified person on their behalf has 2 opportunities to issue notices. The first one is the payment notice, which, as we've seen, is a certificate under the JCT. So you just do, you get a QS to do the valuation, you issue a certificate, that's the payment notice effectively under the Act. So and that's, so this is the original certificate you'd be issuing. Now, for a variety of reasons, you may decide that you want to pay less than that. I've mentioned liquidated damages, but it could be that there's defective work. So in that JCT 4-day, only very brief 4-day window of opportunity, you could still issue a pay less notice, and the notified sum that came about by virtue of the payment certificate can be trumped by the pay less notice. Exactly going back to the Act, it's an intention to pay less than what was on the certificate. You've only got, well, dependent upon the contract, and lots of people, let's take local authorities. Local authorities in particular, they're going to change the 14-day JCT into 21 days, 28 days, because the Treasurer's Department can't raise a cheque and make the payment. So there, you would have a situation, if they don't amend the Payless notice, 5 days before the 28th day, they would still be able to issue a Payless notice. So there, they've had, 21, they've had 28 days, less 5, so they've had 18 days in which to issue the Payless notice. So it's always so many days before the final date for payment. And that's why contractors will always, or lots of people will amend that to give themselves right up until the 11th hour. So they'll say that the final date for payment, the Payless notice, is 1 day before the final date.
Oh, that must be specified, yes.
It must all be specified. You've got a window within which to issue it. No, you can issue it anytime within that window. Yeah.
Can you please clarify the payment certificate notices? Did you say that an interim payment must continue even after practical completion has been achieved and there is a 0% value certified?
100% yes. Under a JCT, you must be issuing certificates every single month, even if the value is 0. And this is where so many CAs get into trouble. And what happens is a contractor puts an application in. Now, as long as it's not fraudulent and clearly nonsense, he puts in an application with a loss and expense claim for £200,000, and you have to pay it. And then, of course, he may or may not go bust. Well, if he goes bust, where's the employer going to look for recompense? He's going to sue the CA because the CA didn't do what was required of him under the contract and issue an interim certificate. So I see this for QSs, I see it for BSs, I see it for architects. It happens frequently, I'm afraid, because the payment mechanism I've explained tonight is a little bit more complicated. I've given you a simplified version. It's not easy. QSs get this wrong, building surveyors get it wrong, architects get it wrong. It isn't straightforward, and you will often need advice on this. Yeah. Yeah. You still have to do them. The same thing applies. So the question was, if the contractor hasn't made applications in the rectification period, do you have to bother? Yes. It's a certifying contract. You have to issue application. You've got to issue your certificates all the way through until final completion. What opportunity? Oh, at final certificate, yes. No, everything finishes at final certificate. Final certificate brings an end to all of this. So all of this situation, the wording is from the, each cycle, from the start of the job up until the due date for the final certificate, the architect should be doing this every single month.
He's actually exemplary in the final certificate. There's no potential.
Oh, well, yeah, right. The question is, if the architect, you use the word default, so if he doesn't issue interim certificates during the rectification period, right, you're temporarily offside and you're running for, you're running likely to get shot at here. But no, once you issue the final certificate, that then brings a close to everything, because that then trumps all of the interims. And there is a final reckoning and an adding up one way or the other in the final certificate. Yeah. Right. Should a QS be telling the architect, how can I say this nicely? Isn't that our job to be telling them what to do all the way? Isn't that what that wasn't our training, Well, you have to tell them. You have to tell them, because otherwise they could get sued. And I'm afraid, welcome to my life. I've been doing this the last, 40 years. And again, I'm not being rude at architects or CAs, but if they administered the contracts correctly, I wouldn't have had a career. Yeah. Speak up. Right. So the question or the statement here is that if the contractor has sent you in a 10-page application, normally an Excel spreadsheet, then you're running the risk if you reply with a one-liner saying 100,000 on account or something like that. Now, I use the word granularity, which is a word I picked up from a colleague, and I like that. So look at if you've got a contract sum analysis and the contract sum analysis breaks it down into lots of different heads, then I would recommend that you use a similar format for your calculation of your interim certificates, because then you're doing it in the detail which would have been under the contract. If you've only got a lump sum contract and the contractor is only putting in lump sums, you might get away with just giving him back a lump sum. But I would always say, show your workings, show your calculation, and then you cannot be wrong. Do you think that that's a fair answer? Oh, no. And yes, I used the word on account intentionally. So somebody in the room has picked me up and saying, don't say on account. I absolutely agree. Don't ever say on account. Yeah, yeah, yeah. There are places, and we didn't get into this with the talks that Seth spoke about, but there'll be places within the JCT where it says that the architect is to ascertain. Ascertain means to calculate. And in the John Barker case, which was over extensions of time, it's alleged that the architect basically had a guess. Well, that's not good enough. You've got to do it with some sort of calculation. So I would recommend all the way that you do a calculation. 40 years ago, I worked in local authority. We used to have auditors in local authority, and they used to come and check our workings. So what we used to do was we would put down workings in the margin, and we'd show that there was a working there. It was nonsense, but at least it showed that there was a calculation, so that it wasn't just an on account or a star item or a say figure. But I'm being facetious, but you've got to show some workings. Otherwise, you run the risk of somebody getting a smash and grab, which is what I want you all to avoid. There was a question, you had a question here. Yep. Yes.
So currently our payment schedule is part subcontract takes us to 2030.
Yes.
If you have a contract that, say, for example, the contract finishes in 2024 and there's an extension of time and the contract went beyond that payment schedule, is it right that the minute it gets beyond that payment schedule, the payment dates? Yeah.
Question from a No, there's an absolute answer to that, and I can give you the case for it. So this is again with the contractor asking about schedules they've set out for payment schedules as between them and a subcontractor, and this would be a series showing that within a 28-day process or monthly process, they'd made sure that they'd given themselves all of the benefits of the dates, but they've also set that up to be schedules for so long. But what we often see is that the schedule goes on for, say, 15 months, and the job was supposed to be 12 months. They gave themselves leeway of 3 months, and then it gets delayed, and it gets delayed, and something happens. Right. If you have a situation where a series of payment schedules expires, then in Grove and Balfour and Beatty, the judge said, well, I'm sorry, you had the right to put a schedule in there. That's the payment system. That's the mechanism. It finishes. You're not entitled to anything more, not until you get to the final certificate. So unless I would, as a subcontractor, I would instantly write and amend that and say, and thereafter to be the same date of the month as the last one, so that I would never let a subcontractor accept a contract that had a schedule. You say that yours goes on to 2030. Well, that's fine. It's unlikely you're going to have a contract running that long, but the subcontractor has got to, yes, if you have a series of dates in a schedule and those dates have expired or have the chance of expiring, tough titty on the payee. You had an opportunity to counter it when you entered the contract. You weren't cute enough to pick it up, and you won't get paid anything then. And again, I've just finished an adjudication, and in that adjudication, the series of schedules ran out in February. So and they're not, and it's not a practical completion yet. So they're out of time. Or yeah, fine. Yeah.
And obviously, you're not going to get a payment. You're not going to get a payment application from every subcontractor for every month. So should you be issuing default payment notices to the ones that don't issue payment notices? Yeah,
don't use the word, right. Question, you're working for a contractor, you've got 50 subbies, and you're not going to get applications from all of them. The question was, do I issue a default notice even though they haven't made an application? Well, you can change the mechanism. You can write into your subcontracts that they have no right to apply, and therefore their application for payment can never become a default notice. So you've got the right to change that, because it's only where the contract permits or requires, right? So that you can change that firstly. Secondly, you can make sure you have these things on different dates. And thirdly, don't call it a default. The default is the one that the subcontractor puts in if you don't do one. But if I'm working for a contractor, I would immediately write out the application becoming an automatic. So they've got to put in a default application, which I would have to make on pink paper in triplicate with bells and whistles to the MD and by fax to the site manager. And then, and only then, would the default application be a valid default application, because it then means that I've got alarm bells that I've got to now do a Payless notice against it. So there are mechanisms, but that was not the subject for today.
No.
Yeah. ladies and gentlemen, I'm conscious of time. It's now coming up to 8 o'clock. I hope that's been of some use to you. I hope that that's brought to a nice close the series of lectures that we've been doing. We're going to be doing, as I say, in less than a month's time, I think 4 weeks tonight, we're going to be doing the talk on the JCT. But I hope that you found that useful. And can I therefore thank you for coming along? Thank you to people online. And we hope that you're going to be coming back another time. So thank you.